everybody. I'm Judge Princess Ongkeko. I'm currently the executive judge of Santa Cruz, Laguna. This is my new YouTube channel. As you know, for those of my friends in Facebook, I've had my personal page, and then I've had my public page. So this is just my YouTube channel now. All I want to do is tell about life and tell about legal matters sometimes. So I've invited two of my very good friends. Judge Cecil Chua is the executive judge of Batangas.
Do I have to state my age? I don't mind.
You look
I'm
25.
56,
You look
turning
25, so I look very
57.
old.
With two grandchildren. I'm very proud of them. My eldest is a doctor and soon to be aesthetic surgeon. My second is lawyer. She's working in Makati. And my third is also a doctor. And my youngest is hopefully will be, at this time next year, is already a lawyer.
So let's hear Attorney Jess or Jesus Falsis.
Ako po yung infamous lawyer in the same-sex marriage case. So I'm also the brother of Nico Falsis. Baka kilala niyo yung kapatid ko ni Cardo Falsis. Google niya lang din kung ano po yung controversy niya. So involved po ko sa mga infamous scenarios. Thank you for having me, Judge.
You know, this is the first episode 1, season 1 of my YouTube channel. I decided to contact my best looking friends and the friends I knew who are very wise and very interesting as well as very intelligent. Today's topic really is about plea bargaining. You know, in Laguna, we had some problems before about plea bargaining. We had a number of cases where for a minuscule amount of drugs, people would go to jail. When you are apprehended because of under the dangerous drugs law, it's no joke. Because if you're caught selling, that's life imprisonment. Basically, you have selling, you have possession. If you possess even a tutor or a pipe for smoking marijuana or shabu, that's also punishable. The Supreme Court came up with a case of Estipona versus Lobrigo. It involved a plea bargaining case. The guy, Estipona, was charged with, I think it was possession of illegal drugs. They were asking, is this a problem during the Duterte administration? No, it's even before Gloria Macapagal. In fact, I came up with a blog on my Facebook about laglag droga. I said, if you've heard about laglag bala, there's such a thing as laglag droga. We know that a lot of policemen are really good, except that sometimes, whether it's in the judiciary or the police or anywhere, there are bad eggs. Sometimes in their zeal to make an apprehension, you cannot help that sometimes they do plant evidence. As judges, we don't know if the evidence is planted or not. The thing is, like in my case, I have had lots of drug cases where the drugs involve a very minuscule amount of drugs.
Anong pinaka-konting drugs na encounter mo sa court mo, Judge Princess?
Nako, less than 1 gram.
Meron pa sa akin Attorney Jess? 0.01.
Pero
talagang wala na. Halos talaga ng 0.01.
Ang pwede lang mag-plea bargaining yung less than 5 grams, Parang ang 5 grams ata is 1 teaspoon lang ata yun or something. When you encounter the apprehensions, parang it's just a dot on a very small plastic. We're talking about the Comprehensive Dangerous Drugs Act. There's a particular provision there, yung Section 23, that states that basta subject ng dangerous drugs, hindi pwedeng mag-plea bargain. Ang gusto ni Estipona, hilingin kay Judge Lobrigo na, pwede ba mag-plea bargain kami? Kasi napaka-konti, parang 0 point something lang, minuscule amount of drugs. Sinabi ni Judge Lobrigo, ay hindi ko pahayaan kayong mag-plea bargain kasi ang sabi ng Supreme Court, kaming mga RTC judges, kailangan modest tayo. Wag masyadong mayabang tayo na, sige, i-declare natin ng unconstitutional. Kaya hindi pwede, wala akong kapangyarihan na i-declare yan ng unconstitutional. Ang ginawa naman nitong si Estipona, nag-file siya ng certiorari at prohibition kay Judge Lobrigo.
Sa layman's term, pag merong isang kagaya niyan, tayong mga judges, we have to decide, exercise discretion. But then if we go with grave abuse of discretion amounting to lack of jurisdiction na yon, iaakyat tayo on a certiorari. Prohibition, kabaliktaran na you are being asked na not to do a particular thing, hindi mo ina-apply o ginagawa ng tama ang trabaho mo. So, para ma-prohibit ka, as the term implies, akyat sila Supreme Court para ang higher court ang magsabi sa mga judges na wag mo gawin yan.
Gusto nung nila Estipona i-prohibit si Judge Lobrigo na to further hear the case kasi gusto na nga nilang mag-plea bargain tapos hindi naman sila pinagbigyan. Tapos yung certiorari, sinasabi nila na Judge Lobrigo exceeded his discretion. Tapos ang gusto nila i-declare ng Supreme Court Section 23 ng Dangerous Drugs Act na unconstitutional. Dineclare talaga ng Supreme Court, oo nga, unconstitutional naman talaga yung Section 23 ng Dangerous Drugs Act. Magaling talaga yung plea bargaining. Nasa kapangyarihan talaga ng Supreme Court yung plea bargaining na yon. In fact nga sinabi pa pagdating dun sa mga rules ng pleading and practice, hindi na pwede yung Congress ang mag-dictate kasi pagdating sa rules ng pleading and practice of law, ang dapat talagang magsabi ng kung ano ang talagang batas ay ang Supreme Court lamang. So after that Estipona case, ang daming nag-plea bargain. Ang dami naming mga na-dismiss na kaso kasi nagsabi ang Supreme Court na sige, okay na ang plea bargaining. Kaso mo, after that, dumating naman yung second case. Ikwento mo naman yung case after that, Judge Ceci. Ano ba yung case na yon?
Before ko muna ikwento yung sinasabi mo, yung isang case na yon, dapat maintindihan din nila na kaya nag-come up ang Supreme Court ng circular on plea bargaining. Dahil nagkagulo yung mga judges. Wala talagang walang regulation, walang rules on how to apply it. Nung nakarating yan sa Supreme Court na yung mga judges nalito na, nagkagulo na, yung iba, ito yung ina-apply. So the Supreme Court came up with this circular nga na pinapayagan ang plea bargaining. Pero may limitations yun eh. So ang pinapakwento ngayon sa akin ni Judge Princess, yung People versus Siren.
Okay.
Noong May 2018, meron ng circular ang Supreme Court. Kasi kadalasan naman ng mga drugs, di ba? Possession at saka selling. Pag sa possession, pwede ka lang mag-plea bargaining pag less than 5 grams. Pwede ka mag-plea bargain to Section 12. To Section 12 lang yung gusto nila eh. Kasi pag Section 12, 2 to 4 years ang penalty, pwedeng mag-probation. Sa selling naman, less than 1 gram, pwede mag-plea bargain. Si Siren na ito, gusto niya mag-plea bargain. Tapos yung amount ng drugs niya, pasok doon sa circular ng Supreme Court. Ang problema, after maglabas ng ang Supreme Court ng circular nila about kung alin lang ang pwedeng mag-plea bargain, ng rules nila, naglabas ng sariling rules ang DOJ. Eventually pumayag na rin sila sa yung possession ng less than 5 grams na mag-plea bargain sa Section 12. Pero sa DOJ, kahit less than 1 gram, hindi sila pumapayag sa Section 12 na ang penalty, paraphernalia, which is punishable by 6 months and 1 day to 4 years. Ang sabi ni Siren, payagan niyo ako dahil sabi sa Supreme Court, pwede na ako nag-object ang prosecution. Ang ginawa ng judge, dapat mag-agree ang prosecution at ang accused, ang defense. Pag hindi kayo nag-agree, hindi ako mag-plea bargain. Dinis-allow ng judge yung plea bargaining. Kasi Siren, syempre, hindi siya happy. Ang ginawa, umakyat sa Court of Appeals. Tapos, eventually, sinustay naman ng Court of Appeals yun, akyat pa rin siya sa Supreme Court. Sabi ng Supreme Court, ito ay internal ng DOJ. Kung hanggang kailan, hanggang saan lang pwedeng mag-agree. May uniform sila na ito lang kayo may authority mag-agree to a plea bargaining. So internal nila yon. Kung sakaling hindi sila mag-agree, yung concept of plea bargaining ngayon ang magpe-prevail, which is kailangan sa plea bargaining with the consent of the offended party. In this particular case, walang private offended party. Ang offended party is the state, the government, which is represented by the prosecution. So without the consent of the prosecution, hindi pwede ang plea bargaining. Kaya sabi ng Supreme Court, tama ang ginawa ng judge. In-uphold niya lang yung principle behind plea bargaining as existing ngayon sa ating rules of court. Ito namang ikukwento ni Attorney Jess ang mas matindi.
Attorney Jess, kamusta ka na dyan?
Sa People versus Rhea 4. Dito, of course, same facts usually na may nakasuhan ng criminal case of Comprehensive Dangerous Drugs Act. Dito, two sachets ng point, malaki naman compared doon kay Judge Cecil na kaso. Dito sa kanya, 0.149 grams of shabu, 2 sachet. So baka mas visible, no? So sa RTC ng Naga, kinasuhan siya for selling. Si Rhea 4 gusto niya i-plea bargain yung kaso niya. Ang prosecution, ayaw nila i-plea bargain yung kaso, but the judge granted the motion for plea bargaining over the objection of the prosecutor or the prosecution sa kaso ni Rhea 4. So nung umabot sa Supreme Court, ang question sa Supreme Court, can the judge approve the plea bargain over the objection of the prosecutor or the prosecution? Sabi ng Supreme Court, and na-mention ni Judge Cecil kanina yung elements, and itong elements naman to existed before this case, but emphasize ng Supreme Court yung third element. No? So sabi ni Judge Cecil kanina, application or consent of the accused. So kung gusto niya mag-plea bargain, dapat nandun siya. But the consent of the offended party, and in this drugs, wala namang specific offended party like in rape or murder. So the state, represented by the prosecution, ang offended party, the consent of the prosecution is important, indispensable. Indispensable na hindi daw siya pwedeng mawala before the plea bargaining can be approved. In the end, the Supreme Court said, since nag-object yung prosecutor, the judge cannot approve the plea bargaining motion of the accused si Rhea 4. Ang impact po ng kaso na to, November 2020, na the prosecution must consent, must agree to the plea bargaining. Otherwise, walang plea bargaining na pwede.
Actually, yung last case na nakita ko dyan, na 2021 lang yung Boras, it simply reiterates the Saire and Rhea 4. Ito minuscule amounts din. Sinasabi lang na kailangan talaga ng approval ng prosecution bago pwedeng husgahan ng judge. Kaya yun. So in effect, yung mga subsequent cases dun sa Lobrigo, parang nawawala na ng kapangyarihan talaga yung judge na mag-plea bargain dahil dapat aprobado ng prosecution. So, anong masasabi mo dyan, Attorney Falsis?
Ano po, no? So, syempre, ang Philippines, developing country tayo, and meron din tayong parang history of corruption, no? Some part of this Supreme Court cases, ang impact niya is to give more power to the prosecution to be a bit more corrupt or to have the opportunity to be corrupt, because otherwise, kung hindi sila papayag, walang plea bargaining. So may incentive po ngayon yung accused tsaka yung lawyer nila. Hindi po lahat, hindi ko po nila lahat. Sinasabi ko lang na meron ngayong space or opportunity na the prosecutor kailangan talaga suyuin, even to the point na baka merong corruption. So that's just one aspect lang po.
Judge Ceci, may comment ka ba dun sa mga kaso natin?
Sa tingin ko naman, Attorney Jess, kaya rin sila naglabas ng sarili nilang DOJ circular on plea bargaining para uniform ang rules nila. Para it will not be dependent on the personal whims and caprices of a particular prosecutor. Kung halimbawa sa amin sa Batangas, meron lang na mag-object ang prosecutor dito, pero talagang within their circular naman ay kapayag-payag, I will call the attention of the city prosecutor and I will even bring him or her to the DOJ secretary na, oh, within the ano ninyo, anong ibig niyan sabihin? Pwede niyong payagan, di siya pumapayag. Halimbawa, may mga ganon sa ibang lugar, o yung mga viewers, within the ambit or within the parameters or limitations set by DOJ, tapos hindi papayag ang prosecutor, baka tama yung sinasabi ni Attorney Jess dyan. Baka naghihintayan. Bantayan nyo yan na pwede naman, tapos umaayaw, sumbong nyo na. Oo.
Kasi sa akin, alam mo, in my opinion, I really love this plea bargaining. Kasi makikita mo naman, tsaka pag repeat offender, bakit mo naman pa plea bargain kung uulitin? Siguro kung first offender, pwede. Tsaka meron talaga yung mga nang papain. No? Meron kaming mga kaibigan sa simbahan, no? Meron silang parang 25-year-old son ata na may nakilala sa Facebook. Ang sabi ng babae, ay to, bigyan kitang 8,000. Bili ka lang ng ganitong droga tapos happy-happy tayo. Naengganyo naman yung bata, bagong kilala. Kinuha yung pera ng babae, bumili tapos miniting yung babae. Yung pala, pain pala yun na para siya'y mahuli. Ang problema kasi dito sa plea bargaining, okay na ako doon na pag malalaki yung amounts ng droga, don't allow plea bargaining talaga. Pero kung napakaliit naman ang amount ng droga tapos first offense naman. Imagine kung minuscule yung amount ng droga pagkatapos yung taong maaakusahan hindi i-allow na plea bargain. Pwede bang makulong ng habang buhay na wala pang 1 gramo yung nahuli sa kanya?
Inisip ko po by logic, parang yung mga akusado po ba, minsan sinasabi nila, ninilis po ba nila yung parang defense or parang paliwanag na how could they have that very minuscule amount? Nasisinghot ba yun? Nagagamit po ba yun? Parang, doesn't it seem absurd po?
I was challenging yung PAO natin na to make a study kung ano ang amount ng drug, supposed to be effect ng drugs na yun, pag mga 0.0 ganito, ganyan, walang study. Kung talamak ka na drug user, paano e-effect pa sa'yo yung hawak mong 0.01 na yan o 0.02 na ito? O kaya kung nakakapanood ngayon ng mga defense counsels, mga ganito, gumawa kayo ng study para pag may hawak kayong kaso na ganyan, mai-argue nyo yan.
Ito, baka tanong din sa utak ng mga tao, no? Siyempre, doon sa isang kaso na na-discuss mo, Judge Cecil, Supreme Court guideline kung ano yung mga lesser offense ng Comprehensive Dangerous Drugs Act versus the DOJ circular. Sabi ni Judge Princess kanina, yung Comprehensive Dangerous Drugs Act, special law, and sa ating mga lawyers, no, hindi siya traditionally pasok na parang may lesser offense kagad na itong crime na ito yung mga lesser offense niya na pwede ka mag-plea guilty. Hindi siya parang klaro agad. Nag-issue yung Supreme Court, si DOJ nag-issue din, pero sabi ng Supreme Court, internal lang. But we know may difference. Importante yung difference kasi sa Supreme Court parang usually mas favorable to the accused. Mas makakakuha sila ng lower sentence, ng mas mabilis na probation. Sa DOJ naman parang mas strict. Hindi ba parang mas tama yung assessment ng Supreme Court? Ano yung mga lesser offenses na nakapaloob sa isang crime compared sa DOJ? Ako lang po as a layman lawyer, no, baka inisip din ng mga dapat Supreme Court yung sundin, hindi yung DOJ.
Ang sagot dyan, Attorney Jess, unlike doon sa felonies under RPC na may mga titles dyan, pag under the same title, pwedeng doon mag-plea bargaining. Kaya nga lumabas ng circular ng Supreme Court. Pag ito yung kaso, dito ka lang pwede mag-plea bargain. Kung saan lang inalaw ng Supreme Court dito, hindi ka pwedeng lumabas dito sa pagpipilian mo na ito. Short answer is, provided na ng Supreme Court yung mga sections the accused can plead guilty to under plea bargaining.
May value ang plea bargaining. Pero Dito po sa mga kaso ng drugs, kailangan tingnan din po natin siguro. The drug cases in relation with plea bargaining can be abused and can be exploited either because of corruption or may mga inosente po na magpi-plea bargain na lang, nataniman sila ng napakalit na amount ng drugs. Ang choice ng isang tao na 0.1 gram na akusado, life imprisonment or parang 6 months to 4 years na pwede yung probation. So, kahit inosente siya, magpi-plea bargain siya eh.
Bago itong mga plea bargain na case, na-approve ang plea bargaining dahil dun sa Estipona versus Lobrigo, marami talaga akong convictions. Dati kasi parang pag sinabi sa akin, ay, na-plant lang na sa amin, judge, parang ang hirap maniwala, parang storya lang ng lelang mo, sinong sasabihin mo yan. Pero it happened in my neighborhood to my good friends na talagang naplanta ng drugs yung anak nila. Tapos alam naman namin na yung storya talaga. Kaya minsan kailangan maging bukas din ang mga utak natin ng mga huwes na sometimes it is the spirit of the law. Although we have no choice. Sabi nga nila yung mga minsan daw, ang mga kaso mas magandang inaareglo bago dumating sa judge. Kasi bagong dumating sa judge, pwedeng mawala na yung mga ebidensya eh. Kung nandun na lahat yung ebidensya, pagkatapos palpak pa yung gagawin mo, ay talagang may nangyari siguro. Kaya ang tawag dito, mag-ingat lang please. Thank you, Judge Ceci. I love you, Judge Ceci. Thank you very much, Attorney Jess. Kayo mga angels ko. Alam nyo, bago itong show na to, gumawa kami ng Facebook chat group. Ang nakachat ko si Maria Cecilia Chua, tsaka si Jesus. I mean, how can I go wrong with Maria and Jesus? Mga angels ko for my first episode. I really love you guys. Thank you very much for bearing with my first episode. And God bless the two of you.
Thank you for having us also.
Okay, sige. Thanks a lot. Bye-bye.
Thank you po, judges.